Well, for the legal implications of this latest development, we turn to an attorney who's been practicing criminal law for over 25 years. His name is Jim McGurk. He heads his own practice in Chicago and is the former assistant U.S. attorney and currently sits on the federal defender panel. He joins me now from Chicago. Welcome, Jim.
Good to be here. Thank you.
Jim, let's talk about the change today that has happened. I mean, this really is earth-shattering. Put it in perspective for us.
The prosecution brings a case only when it believes it has a strong case. In this case, a very powerful individual was charged. They are now stepping back in their bond. They themselves have introduced evidence that seems to suggest real problems with their case. Very significant.
Now, there was some concern voiced earlier today as we've been speaking to people that perhaps the prosecution went too far initially. Do you agree with that?
I don't, in the sense that these were very serious allegations. They had evidence at that time. If they had not acted, I believe they would be accused of somehow deferring prosecution against a wealthy and powerful individual. So I believe that they acted appropriately with the evidence they had at the time they acted.
And you're saying now that the evidence, or I should say more evidence, has come to light, they're acting appropriately now. So they acted appropriately then, they're changing, they're acting appropriately now. Is that the case?
In my view, they are. The Constitution requires that when the government, the prosecutors and the police learn of evidence that is favorable to the defense, they must disclose that, they must act on it, and in this case, I believe they have done that. And I think they're acting appropriately.
So would you say that this whole process effectively supports the current system of justice here in the U.S., or do you think that in any way it undermines it?
I believe this supports the system of justice in the sense that prosecutors and the police are sworn to uphold the law, and that means following the evidence where it leads. And in this case, if the evidence demonstrates that there is problems of credibility with the key complaining witness, they must act on that.
Now, Jim, there may be some parallels between this case and what happened down with the Duke lacrosse team in North Carolina a couple of years ago. Can you sort of connect the dots for us, please?
Well, in the Duke lacrosse case, the prosecution either chose not to follow or ignored very substantial evidence that undercut the prosecution, potentially because of political reasons, because of a pending political campaign. Ultimately, the prosecutor in that case was sanctioned. That is an example, if you will, of the prosecution not following its obligation to pursue the evidence where it leads. I believe the prosecution here is acting in a way consistent with the Constitution.
Now, Jim, just quickly, before we let you go, and thank you for joining us, by the way, any chance that Dominique Strauss-Kahn is effectively a free man within a week or perhaps 2 weeks?
It is certainly possible that the evidence that will demonstrate for the prosecution that it's not worthwhile to proceed for trial, and therefore it is a potential. They could drop the case or dramatically reduce it to much less significant charges.
Well, dramatic indeed. Thank you very much, Jim McGurk, for joining us from Chicago. I'm sure we'll be talking to you several times over the next several days.